May it please.
Item number 4, my lord.
Item number
4.
4. What happened?
The issue involved in this petition is pending before the Honorable Supreme Court.
Okay, let the orders matter be called out. Wait for a while.
My lord.
Okay, it will be called out just now.
My lord, may it please, your lordship.
Yes, Mr. Goel.
My lord, as regard item number 11, your lordship, with the
Mhm.
consent of other side, can it be taken up, my lord, after vacation, my lord?
What do you say? Mr. Goel appearing for the respondent. That income tax exemption. Praise for time. Mr. Standing Counsel, Mr. Kale does not object to the request for adjournment. List after the ensuing puja break.
Much obliged.
Deeply obliged.
It is, my lord. My lord, may I kindly pray for an adjournment in item number 15, my lord.
What happened?
My lord, there is some personal difficulty on the part of Mr. NMB.
What's your good name, sir?
As they, my lord.
Mr. S. They representing the petitioner place for time. And the other side has no objection. List up to 4 weeks as great.
My lord, it is a fresh matter, my lord.
So then you argue PIL, what is to be done?
Next
2 weeks, all right.
Wait,
Much
please, Lordship.
obliged.
Lordship, I beg to mention item number 22 of today's list.
22.
Lordship.
What happened?
Lordship, we have some difficulty. Lordship, in fact, in this matters, section 16.
You're bound to have difficulty. Last date, we had
Lordship.
virtually heard the matter.
Lordship,
Mr. Kale has given us 2 judgments which
Lordship.
completely cover the issue.
So I pray for some time for.
Lordship, in the meantime, Patna High Court has also dismissed.
That's a very logical view which you pointed out.
No.
All right. A request is made to adjourn the matter on behalf of Senior Counsel Dr. Ashok Saraf, representing the petitioner. Mr. Kale does not object. However, he submits and that the Patna High Court has also decided the controversy which covers the issue against the prayer made in this writ petition. List after 2 weeks has been.
Much obliged.
May I please, Your Lordships?
Yes.
To mention item number 20, Your Lordship. Kindly further time may be granted for filing of reply, Your Lord.
Filing of reply affidavit.
Yes, Your Lord.
Counsel for the petitioner pays for and is granted further opportunity of 2 weeks to file
20.
affidavit in reply. What happened?
20.
20. Oh, 20. ITA. Why do we need affidavits in ITA?
Filing of reply.
These are appeals arising from the records of the courts below or the tribunals below. Why do we need affidavits in this case?
It's important.
Don't make.
It's necessary. Lord. Filing of reply is necessary, Your Lordship. Kindly.
Has the other side, has the appellant side filed any affidavit?
No, Your Lord.
Then what for you are seeking adjournment? Give us a logical reason. Let the matter be called out. We'll see.
Lordship may kindly taken up next week, Your Lordship.
Just let the matter be called out. Wait for your turn.
May it please, Your Lordship, I'd like to mention item number 16, Lordship.
Yes.
Lordship, kindly adjourn this matter for 2 weeks. We need to-
You're not informed us, you're not circulated a slip. It is just in the morning you stand here and make a request for adjournment.
Extremely sorry.
This
Lordship.
is really unfair on your part. Counsel for the appellant. You're for the appellant
No, Lordship, respondents.
or the respondent makes a prayer for adjournment. What about Ms. Saikia? Who's there? The other side? You're not informed
We
the
have
other side.
informed- We have informed.
All let them come then. Let the matter be called out.
May I please, Your Lordship? Your Lordship, I beg to mention a writ appeal for listing. We filed the writ appeal yesterday, Your Lordship. So Your Lordship, I pray the matter may be.
What is
listed
the
tomorrow.
urgency?
The appellant is a medical aspirant, Your Lordship. Her admission was cancelled unilaterally pursuant to a couple of orders passed by this Honorable High Court.
So we have passed a general stay in that
Your
matter.
Lordship, however, the appellant was not a party to the writ petitions.
All right, tomorrow.
Much obliged, Your Lordship.
May it please, Your Lordship. I just mention one item, my lord, that was listed on 23rd of August, returnable by 4 weeks.
Hmm.
And the matter is pending for last 5 years, my lord, since the 19. There's some urgency because appointment of this.
Move an application for listing. Move an
can it be-
application for a listing. What is the next date? Pending matters can't be listed.
23rd, it is over, my lord, 23rd of September.
Find out, Zakir. Get
23rd
it
of
listed. We'll get
September.
it listed in the next week. Or let's get it
Next week,
listed.
Not on 10 or 13, I will be having some difficulty. Other date, any date.
Get it listed on Friday.
Obliged.
Hey, please, Your Lordship. Your Lordship, today, just now, we have filed our two IAs into connected writ appeals for vacation of stay order, notification stay order. May I pray the matter may be listed on Tuesday, this coming Tuesday?
2263 you have filed. So why do you need to make a mention? The office has to list it
IA,
in 14 days.
IA
So IA for vacation of stay,
for vacation,
under what provision? 2263.
2263.
So then the office has to list it in 14 days. When did you file it?
Just now,
Just now.
Yes.
All right, get it listed on Tuesday.
highly obliged.
Okay.
Daily list for order, item 3 and 4.
Yes. What was the matter pending for Supreme Court?
Yes, my lord, still pending, my lord.
The matters pending before Honorable Supreme Court as referred to in the earlier order sheets, orders, earlier proceedings has not been decided. Thus, consideration of this PIL is deferred by 12 weeks, awaiting outcome of the matters pending before Supreme Court.
Item number 5,
So this controversy we have decided against you on merits, that kilometers.
Lordship, my lord, in a similar case, the Lordship has, my lord, delegated the parties to the, before the grievance adversary committee, in-house remedy. And my lord, the petitioner
no.
here also made a prayer before the, for.
See this judgment covers your appeal. GB Chaudhary Holdings. That is the issue in this writ appeal.
My lord, may I just examine it, my lord, let it come after.
All right.
Vacation.
Let it come up after 1 week,
After the vacation, I'll be.
after puja break, as paid list after puja break. Ms. Chaudhary, you can collect a copy of this judgment. It would help you.
item number 6 to 8.
Yes. You are for the respondent.
Yes, my lord.
Your client is playing hide and seek or what?
No, my lord.
In every matter, they have to get it served after making efforts. Yes, all right. What do you say to IA?
My lord, 13 days delay, my lord.
My lord, 13 days delay, my lord. There are 3 items which has come up, my lord, 6, 7 and 8. In item number 7, there was no stay order during the writ proceeding, my lord. Therefore, my lord, in item number 7, we are not interested in the work anymore. So it should become an academic exercise that may be closed. But as far as items 6 and 8 are concerned, we'll be contesting, my lord.
Let the matters be heard.
Let the matter be heard. All right. We condone all 3. List for admission on Wednesday.
My lord, item 7 already delay had been conducted.
Item 7 delay condone हो गया.
6 and 8, my lord.
6 and 8 delay condone.
13 days,
IA allowed.
my lord.
7 along with हो जाएगा.
Obliged.
Name of Mr. Biswas. SC Biswas.
Monojit M. Biswas.
M. Biswas. Okay. Shall henceforth be reflected in the contest.
Obliged.
As counsel for the respondents.
Item number 9.
9, my lord, I'll seek an apology, my lord.
You have not taken the steps.
Steps yesterday taken, my lord.
Mr. Gogoi submit that he has taken steps for service yesterday. Register to check and proceed.
Obliged, my lord.
Item number 10.
The delay of 10 days, my lord.
But the service has not been effected.
My friend is appearing.
You are appearing for 2 to 4.
Yes.
All right. What do you say to delay? Delay of 10 days condone. Rate appeal to be numbered and listed for admission after a week. I allowed.
Item number 12.
Who made a mention in this one? Yes,
May I please, your lordship?
yes,
Sir, maybe pass over for time being, lordship.
okay. We have asked the Principal Secretary Health to join the proceedings.
He is the additional chief secretary, my lord.
Okay, okay.
Sir.
very well. Yes, Mr. Joshi, why do you
Sir.
seek a passover, madam? The officer is here. The officer has joined the hearing. Why do you want
Yes,
a
sir.
passover?
Lordship, semi-senior is on legs, lordship.
This is not fair. All right, Ms. Joshi, will ask the government council to inform you when the matter is taken up again. You can
Sir.
join again. Okay.
Sir, thank you. Item number 13.
Yes. This the office report has come. All right, take down. In pursuance of the order dated 26/9/2023, the registry has made a report. पहले ये लिखिए. This intra-court writ appeal arises from an order dated so and so passed by this court in the criminal writ jurisdiction being writ petition criminal /5/23. The said writ petition preferred by the petitioner appearing in person was dismissed filed by the petitioner seeking quashing of the FIR as well as the charges framed against him by the trial court was dismissed by the learned single judge by the order dated 8/6/23. On the previous date of hearing, we had instructed the registry to make a report regarding maintainability of the writ appeal. Full stop. The registry has the office note dated 3rd October 23 indicates that the Guwahati High Court rules are silent as to whether an intra-court appeal would lie against an order passed in a criminal matter by Honorable Single Judge of this court under Article 2 to 6 of the Constitution of India. Guwahati High Court rules, Rule 2 to Chapter 5A. Honorable the Supreme Court, in the case of the Ramkishan Fauji versus State of Haryana and others, reported in 2017 volume 5 SCC 533, has laid down that letters patent appeal does not lie against an order passed by single judge of the High Court in exercise of the criminal jurisdiction. In the said case, the writ petition was filed under Article 2 to 6. Writ petition before the single judge of the High Court was filed under Article 2 to 6 of the Constitution of India. And the division bench, entertained a letters patent appeal against the order of the learned single judge. In this background, and keeping in view the law as laid down by Honorable the Supreme Court in the case of Ramkishan Fauji, we hereby direct that suitable insertion shall be made in the Guwahati High Court rules, clarifying the position that no intra-court writ appeal would lie against an order passed by single bench of this court excising the criminal writ jurisdiction. In wake of the discussion made here in above, the instant intra-court writ appeal preferred by the appellant is dismissed as being not maintainable. What was the practice, may we ask? Writ appeals were being entertained previously, Ms. Chaudhary? You might be knowing. Arising from single bench writ orders in criminal jurisdiction.
Yes, my lord.
They were being entertained.
It has not been entertained, my lord, to my knowledge.
Well, they registered this one. That's why we were a little taken aback that how appeal has been filed from a criminal writ order.
Any, my lord, since your lordship has observed that some amendment.
No, we'll ensure that the appropriate insertion is made in the rules.
Fine.
Whereby basically it is 227 kind of a writ.
True.
So 227 appeal would not lie.
Item number 14.
Yeah, appeal doesn't lie. Yeah. Yes, please.
Yes, my lordships, this appeal actually against the single order passed by the single judge, my lord. Here I'm just lordship go through the state petition, my lord,
State petition
of that memo of appeal.
along with the appeal. Let's see.
That goes through, huh? The page 43 of the operative part, my lord, the judgment.
43
Three.
of
Of
what?
the state petition.
Okay.
The judgment part.
No, but this is the final judgment, we suppose.
This is final judgment passed by the single bench.
Yes.
Single. What I just read out, my lord. Under such circumstances, this court therefore is of opinion that in view of the dispute which has arisen, this court is not in a position to decide the said dispute. And to involve intricate details of evidence. It would be in the interest of justice that the competent authority make a reference to the district judge in so far as the entire petition of vice versa, the respondent number 5. The district judge can well decide as regards the diversity of claims and counterclaims so made by the petition as well by the respondent number 2, 3, 4. And also take into consideration stand taken of the respondent number 5. Accordingly, the court dispose the instant writ petition with a direction to the respondent number 4 to make a reference to the district judge within 15 days from date of receipt of the order. My lord, what happened, my lord? This order, the passed under section 11(5) of that Petroleum Mines Act, that Petroleum Acquisition Act, Petroleum Minerals Pipeline Acquisition Right is there, my lord. I will just give out one copy, my
No, no,
lord.
we have a copy.
You have
Last date you provided, it's
Yes.
lying in the file.
Yes, my lord.
Yes, rules,
Rules, my lord.
but 1963.
Act. If I love to go through the act, there's a
What-
act.
What you have provided is the copy of the rules of
No.
Act
my lord.
of 1962.
Yes. my
Yes, we have it.
lord. You just go through lordship that 11(5) rules. Act
11(5).
11(5), my lord.
Yes, please.
Page 7.
Yes, please.
Yes.
11(5).
11(5).
No, there is no 11(5) in this.
Yes, act is there, my lord.
The last provision in the copy of
11(5) is not there.
maybe Pierre, I am having a wrong set. Can you give another set, please?
Quoted in the judgment itself that your lordship.
Let us have the act.
41, my lord. That has
Uh,
been quoted.
No, that hasn't.
What we are having is, what I am having is, all right, these are the rules, sorry.
Yeah, rules. Act. Yes, it is.
Yeah, all right, we'll have a look at it. 11(5).
11(5).
Yes,
I just read out, my lord. If, yes, lordship.
if any dispute
If
rises.
any dispute as so as to apportion compensation or any part thereof, as to a person to whom the same on any their part thereof is payable, the competent authority shall refer the dispute to the decision of district judge. Within the limit of whose jurisdiction the land or any part thereof is situated, and the decision of the district judge shall be final. Now, my lord, in case of any dispute, here there is no dispute at all. What happened, my lord? GAIL is an undertaking, government of India is a Maharashtra company for laying. they have taken the
Interested,
work of-
that dispute is interested between those two claim, those people who lay a claim of ownership, that is the dispute.
That is.
So that is interested,
No, my lord, there is not ownership dispute.
user, User.
against whom, upon whom the pipeline laid down, he is entitled to get a compensation.
Yes.
No, my lord, what happened, my lord, in this case particularly, I'm just explaining, my lord.
Mm.
There the land is belongs to 666 dogs. 666 dogs, there are so many pattada,
Yes, yes.
The particular land is laid upon a particular portion of land, which is which is in the possession of respondent number 4, Simoti Gulbani Boygam.
Yes.
Respondent number 4, my lord.
Yes.
And what happened? And the petitioner in the writ petition, he is also one of the co-pattada. Now, thing is that, my lord, since the land is laid upon the pipeline is laid upon that particular land and belongs to respondent number 4, the GAIL authority has decided to Panchanama has been drawn in favor of respondent number 4. But unfortunately, when Latkajari was there given, the Latkajari, the name of the petition was accidentally written. Whatever petition was accidentally quoted. So he got a chance, petitioner. Oh, I'm entitled to get. Now what happened, my lord? That respondent number 4 immediately lodged a complaint before the competent authority that since the land belongs to me and upon the which the pipeline, so I am entitled to get. So court, what happened, my lord? I just read out, my lord. 150, my lord. Just 150.
150 from your stay application.
Stay application. Someone has been
Maybe ask, why you are resisting this order? This doesn't affect you.
Yes, my lord. Why I am resisting? Simple thing. In the summon applications, they have both the party appeared. That time they didn't raise an objection.
Raise an objection. Okay.
That time they didn't raise an objection that I know my London friend will take up that by forcefully.
That is not for the writ court to see.
That is not
for the writ court to see.
Yes, they want to give a criminal overtone of this thing.
All right.
No, my lords. This petition was suppressed in their writ petition.
This application.
This application was suppressed in the writ application.
Okay.
They have not come with a clean hands. And equity, this is a court of equity. The court demands the equity.
What is the impact of this? What is the impact of this letter? What do you want to highlight?
What already the amount has been disbursed. So how can there be two payment, do a double payment? Already amount has been disbursed to respondent number 4. Now, and they were aware of the petition, my lord. They are aware of the summon. They should have ordered.
Summon, where is the summon? Which? Fayaz Ali.
Yes,
151.
141.
151.
151.
Yes.
150, 151.
Right. So this fact, they were given an opportunity to raise an objection.
They were given a raise an objection, but subsequently they didn't raise the objection. But in their petition, they have annexed but particular letter that we have forcefully taken his signature. That fact is totally suppressed in their summon, my lord. And this fact, learned single judge did not take into consideration that fact.
Why didn't you bring it on record?
I have already brought it on record.
On before the single judge.
Before the single judge, but didn't consider at all.
Okay.
They say that already he's supposed to get. How can a double payment? A government of India has no such money that double payment can be made.
No, otherwise also, if there is a dispute of apportionment, our view is that they should approach the competent authority or file a suit against the person.
Yes. Not already competent, then it will open a floodgate.
Yes, Mr. Chaudhary. What do you say?
Then the entire project will hamper.
Yes. Yes, please.
My lord, the civil suit is barred, my lord.
All right, if you go to the competent authority, seek apportionment, seek a relief against the person.
My lord, so far as my learned friend's submission is concerned that there cannot be double payment. My lord, after the objection was read and the my lord petition was heard.
You got an opportunity to object.
Yes, my lord.
Why didn't you file this summon on record of the writ petition?
No, my lord, we have appeared.
This fact, whether it was disclosed or not in the writ petition, we want to know. That you were given a notice to object. What was the consequence?
In fact, my lord, I have appeared and they have passed an order. Your lordship will kindly come.
Let us see the order.
Page 152.
Yes, in the stay application.
In the stay petition itself.
So the issue is what his argument is raising, that you did not disclose this fact in the writ petition.
Yes.
Is it correct?
In fact, my lord, this order has been annexed in the writ petition.
Let us see. Which is the order?
Page 152, dated my lord 20th of March 2021. whereas payment of the land compensation for scheduled so and so was kept on hold on the basis of the petition filed by Faiz Ali, whereas the list of Latka Jari so and so, and whereas the present proceeding for release of compensation have been undertaken on the basis of the petition filed by late Faiz Ali, whereas late Faiz Ali, son of so and so, have appeared before the court. Whereas the statement of Mustafa Ahmed, he is the petitioner, he was the
Yes,
petition,
yes,
was recorded. And
yes.
documents submitted by Fazlul Haq Chaudhary, so and so, all were adduced and produced. Whereas Mustafa Ahmed has submitted NOC stating that
Yes.
no objection
Hmm.
in Srimati Gulban Begum, wife of late so and so, receiving the compensation amount for the scheduled dog. In view of the above, it may be noted that from the certified Jamabandi Sita of the scheduled lands as provided by the circle officer, Rangya Revenue Circle, it is clear that late Faiz Ali, son of so and so, is a recorded landholder of the dog. Since late Faiz Ali, son of so and so, is a co-potter of the scheduled land and have the possession of the pipeline affected area of the scheduled dog. The
Yes.
death certificate of Faiz Ali issued by Naubura.
So you made a no objection.
My lord,
You are not recorded as a no patadar.
no, that has
What-
not, no, that has not been, my lord, disclosed. Prior to this, my lord, the objection was filed by the petitioner.
But when you appeared there, you gave a no objection. What is the competent authority supposed to do? Then it becomes a
No, my lord,
disputed.
my
Mr.
case
Chaudhary,
before the- my
then-
case before- no, my case before the authority is that, my lord, some documents are got signed by them and therefore an
That
FIR
is,
was
that
lodged.
is purely a disputed question of fact.
That's
A
why,
writ
my lord,
court is not supposed to go into that.
that's why, my lord, the writ court should not and should not have entered in
The
meeting, my lord.
Writ
but-
petition was filed by
But
whom?
I cannot, yes, my lord, but I
Writ
cannot,
petition was filed by whom?
yes, my lord, but
So the-
I cannot be remediless. I cannot be remediless. my lord.
Writ is not the remedy, sir. You could have approached the competent authority.
Section, my lord, this is
Apportionment is the task of the authority under 11.5.
true, my lord.
You approach, why should they go? They have already paid the compensation in terms of the order of the competent authority. If you have any objection that your remedy lies not against them,
My lord, the question of double payment.
they have
does
paid,
not arise.
Mr.
They have
Chaudhary,
taken
just
the-
please listen to us.
My lord.
They have paid the compensation in terms of this order passed by the competent authority, right? Why are they supposed to now re-indulge in this issue?
Because, my lord, they have made the payment after my objection and with indemnity taken from the person, my lord.
Sir, the payment has been made pursuant to an order being passed, not on their whims. So they are bound by that order. Can they go against that order?
That's
Or
why,
they
my
are
lord,
they supposed to go against?
that's why, my lord, the petition was before
No,
the
no, no.
honorable
Sorry.
single judge.
No, we are not satisfied. Admit issue notice. Mr. Chaudhary puts in appearance on behalf of the respondent, this so and so, heard on stay application. Then counsel. Sir, your good name, please?
Yes, Mitra, Sanjay Mitra.
Representing the appellant urges that as per section 11.5 of the so and so act, comma, the dispute can be referred to dispute regarding apportionment of the compensation or any part thereof being raised before the competent authority, upon being raised before the competent authority, is required to be referred to the district judge within whose jurisdiction the land is situated. He urges that in the proceedings before the competent authority, comma, summons were issued to the respondent writ petitioner who appeared and gave a no objection. Thus, comma,
No, my lord. No objection was earlier in point of time, which was said, my lord. full
sir,
document.
please read the order. Read the order, 20th August.
My lord, there it says, my lord, my.
So there it is recorded.
No,
If it is wrongly recorded, go back to the authority and say that you have wrongly recorded this. We are only noting his arguments.
my lord.
Appeared and gave his no objection in Srimati Gulbani Begum receiving the compensation for the scheduled dog. The perusal of the order would also reveal that late Shri Fayaz Ali, husband of Gulbanu Begum, was the recorded landholder of the dog in question. In this background, comma, we feel that the contention of Land Council for the appellant that the writ petition was entertained and allowed on seriously disputed questions of facts carries weight. Thus, the writ appeal is admitted, admit issue notice, heard on stay application, number so and so, having regard to the facts and circumstances in the notary of effect and operation of the impugn order dated so and so shall remain in state.
Applied.
Item number 16.
There was a request for adjournment. Before that petitioner, the person has come. The case वापस call करने में. Yes. Yes, why do you want an adjournment?
Lordship, my senior is not well. Senior is not well, Lordship.
Not well. It is stated, Mr. A.K. Sharma,
AK Sharma.
that land council, Mr. A.K. Sharma is not well. In view of the submission, so made, list of 2 weeks. Just hold on, we'll call your case. You wait, we will call your case again. Wait for a while, we will call your case.
Item number 17.
Yes.
Petitioner challenges the Act of 2017, my lord. The similar case was pending, my lord. My lord, similar case was pending, my lord.
Pending issue notice, connect with so and so. What is the number of the similar writ petition?
My lord, a bunch of series, one, my lord, 6287/2020.
Note kar lena. Connect with so and so.
Item number 18.
My lord, the petitioner appellant herein, my lord, had approved the single bench, my lord, for provincialization of his service as a tax collector of a Gao Panchayat, my lord. And my lord, on the basis of, my lord, a memorandum, my lord, page number 48 is the memorandum, my lord.
There are certain directions given by the learned single judge. What has happened to those directions? Whether there has been any compliance?
No, my lord, in regard to the petitioners, my lord, his service is not, my lord, till date, not provincialized.
What is the response?
My lord,
Come to this direction given at para 11.
That advertisement, those posts, 450 posts were advertised and those posts have been filled up.
Filled in,
Yes,
okay.
my lord.
But beyond that, there is a direction.
Till such decision is taken, members of the petitioner association who are being paid fixed wages at the rate.
So-
My lord, we are paying them. His
You're paying, but there was a direction to take a discussion in that earlier order. Respondents are directed to carry out the aforesaid exercise within a period of 6 months from the date of receipt of copy
My
of
lord,
this.
that aforesaid exercise is pertaining to the advertisement dated 27.
Okay, okay.
Not his regularization. His case of regularization was not considered by the learned single judge, my lord. So at best, he can file a review. So that his issue of
All right,
regulation.
Gram Panchayats are debarred from making appointments only against provincialized case.
And my lord, one aspect that I would like to bring to your kind notice is that his appointment is illegal in nature. His appointment was made in the year 1993.
That is not a finding of the learned single judge,
My lord, this is
that the appointments are illegal. Read the finding.
that point.
Read rather, come to para 64.
In view of the discussions made above, maybe and other citations relied upon on behalf of the state have no application to the facts of the present case. Apart having regard to the discussions, engagement of the members of the petitioner association as casual employees in the Panchayati Raj institution cannot be termed as void.
So your submission is not correct. That is a finding recorded in favor of the petitioners.
But
Then you are directed to undertake some exercise. That is as indicated in para 47. What is the exercise?
that exercise is, my lord, pertaining to that
Advertisement.
just limited to the advertisement.
So these posts are provincialized posts or what?
Only 4565 number of posts were provincialized, my lord. At best,
4565.
just that, my lord.
Okay.
He was not covered in those 4565 number of posts.
Okay.
At that point of time when he was employed, or engaged with the panchayat, there was no sanction post, my
No
lord. So
sanction.
he cannot take advantage of.
Yes, what do you say?
My lord, I have annexed, my lord, page number 59, my lord.
Hmm.
This is a document provided by the chief. my lord,
59 of this writ
of
appeal.
Appeal, my lord. I was working in my lord, in the number 1, my lord, Sunai Gaon Panchayat.
Oh, your working is a different thing.
Yes,
But whether you are working
sanction-
against a
sanction
sanction post,
Sanction vacant post, my lord.
or where is your name
Yes, my lord.
in this list?
My lord, name is not there, my this is
Then-
RT application, my lord. Kindly, my lord,
Oh,
page number.
whether you place this document on record of the writ court?
Yes, my lord, that was a part of the report, my lord.
Yes, then what is the finding of the learned single judge?
My lord, on this particular case of the petitioner, there is no finding, my lord. The finding is all the petitioners, my lord, in the batch of the, my lord, writ petitions, my lord.
Hmm,
Not particular case was, my lord, discussed, my lord.
hmm.
So, my lord, regarding, my lord, the
Where is your initial appointment order? Let us see.
yes,
Page 30, my lord.
Page 30, my lord.
30. Let us see who has appointed you.
My lord, the Gaon
Well-
Panchayat president, my lord.
No, the president is no one.
My lord, on the
Is
record-
there a resolution?
Yes, my lord, resolution mentioned, my lord, Gaon Panchayat committee, my lord, held on 24/3/93.
Where are the minutes?
My lord, this is not annexed, my lord.
This is the thing. This,
My lord,
the
regard-
president is no one.
Yes, my lord, regarding this aspect, my lord, the learned, my lord, single judge held, my lord, this is not a void, my lord. This is-
Right, we'll admit your appeal, then we'll see in due course. Admit issue notice. The respondents are duly represented. Thus, notice the process need not be issued. Please for hearing in due course.
As far as one of his cases concerned, there is no sanction post to take the advantage of.
Let it remain
There is
pending.
no continuous service also.
Item number 19.
Made your lordship, my lord. But you always kindly see the order dated 1/2/23, my lord.
1/2/23.
23, my lord.
What is the order, please?
Yes.
That is just an interim opinion of the court. No
No.
conclusions
No,
drawn.
they have to produce that is what the last. That is, my lord, as the condition precedent of invoking section 160.
Records.
Yeah.
Ms. Mazumdar.
Records I have received, and subsequently, your lordship passed an order on 3rd of March. Make the compilation. And for that, I'll just require a couple of days. Day after tomorrow, lordship will take up. I have received the record. Friday, lordship will take up.
All right.
In that
Mr.
case,
Mazumdar,
take my lord.
praise for and is granted. Short opportunity to prepare and submit the summary of the record with an affidavit in terms of the order dated 3rd March 23.
Yes.
List after 2 weeks.
Obliged, my lordship.
Item number 20.
Yes. They wanted to file an affidavit. Why affidavit in appeal?
May I please, your lordship?
My lord,
For the respondent, we are appearing when to file affidavit in opposition.
My lord, in fact.
Why do you want an affidavit in ITA?
Lordship, in this matter, lordship, some mistakes are there, lordship. In fact, we have not formulated the substantial question of.
You have not formulated.
We have. So, my
All
lord,
right, Ms.
we would
Chetya.
also like you, my lord, to file an additional affidavit. my lord.
Praise for and is granted time to file an affidavit with the proposed substantial questions of law.
Lord,
List 4 weeks time is granted
deeply,
for doing the needful. List after 4 weeks.
deeply oppressed.
Item number 21.
May I please, your lordship?
Yes,
Your
please.
lordship, instruction received, your lordship, today itself, your lordship. A meeting going to be held, your lordship, on dated 30/10/2023, your lordship. So
30th or 13th?
30.
30.
30/10. So matter may list after that, your lordship.
My lord, the
Reopening.
issue has already been, my lord, sectioned otherwise.
You already made an observation let them finalize.
But in the interim, my lord, I may be given the. the benefit.
similar matters,
Because
Correct.
so all persons are getting the benefit, my
You
lord.
will get consequential benefits, don't worry. MS Pidas.
Yes, your lordship.
Standing Council Secondary Education submits that meeting for removing the anomalies, meeting of the committee to remove the anomalies pointed out / highlighted in this red petition is fixed on 30th October 23, and the resolution is likely to be arrived at on that day. Re-notify on 9th November so as to enable the respondents to place on record the conclusions / resolutions taken in the meeting dated 30th October.
Deeply obliged.
Item number 23.
But in this case, my lord, I need to submit one order, my lord. Issue is slightly covered by the honorable single judge, my lord, in a different case, my lord. The issue, we have challenged the circular dated 2/2023 issued by this Director of Secondary Education, my lord, whereby a condition has been incorporated in the implementing circular that NOC has to be submitted by the candidate concerned for getting the
Higher education.
in charge principal.
Okay.
Education has been obtained, my lord.
Okay.
The honorable single judge, my lord, has clarified the issue in this my lord writ petition. Stated that, my lord, observed that, my lord, as per section 22 of the UGC Act, read with Rule 21 of the General Clauses Act, my lord, the degree offered by an university, my lord, cannot be declared invalid or otherwise illegal by the third party, my lord. That's why, lordship, my lord, the honorable single judge has allowed that NOC, this condition, the impugned condition should not be there in the
Yes, madam, what do you say?
Your lordship, we are awaited for instruction to file our affidavit. So kindly grant us 3 weeks time.
Let them file an affidavit. They would probably come up with an appeal against this order also in the meantime.
But in the meantime, my lord, I may submit, my lord, the impugned provision of for time being may be stayed, my lord. Because honorable single judge has made
Let
clear
us file
submissions
our
on
affidavit, your
clear
lordship.
settle
On
the
next
petition, my lord.
evening.
This is decided in an IA. Red petition is still pending. How could that have been done?
But the
All right. And counsel for the respondent, respondents praise for his content. Further opportunity of 3 weeks to file their affidavit. First up, while filing the affidavit, the respondent shall account for the directions given by learned single judge in the order dated 28/9/23 passed in IA civil insurance
A date to be given.
list on 10th November.
Obliged.
Deeply obliged.
Item number 24.
What is the number of the writ petition in which this IA was filed? This is incomplete as a matter of fact.
Order is, I will give that. number.
Give the number of the writ petition.
May it please your lordship, after filing this PIL lordship, certain developments have taken place, lordship. With regard to one of the representations submitted by the petitioner, lordship, an FIR has been registered at Naga Police Station, lordship.
Okay.
Copy, lordship.
So what do you want us to do
My
now?
simple prayer is to consider my representation and dispose of it accordingly, lordship. This is my simple prayer, lordship.
So now, when you say that the FIR has already been lodged, what more relief do you want?
Lordship, there are 3 representations, lordship. Only on the basis of the last representation, an FIR has been raised.
All right. The PIL at hand has been filed by the petitioner seeking the following reliefs. And counsel, Mr. What your good name, please?
Keyboard, lordship.
Keyboard Lois points out that the complaint lodged by the petitioner has been now registered as an regarding misappropriation of government funds under NRHM in Nagaon district for the years 2006-7 to 2007-17-18 has been registered as an FIR. What is the number?
FIR, lordship, Nagaon PS case number 216 of
So and so.
2023.
However, the contention of land counsel for the petitioner is that two more representations dated
Dated Lordship, 6/1/23 Annexure I, Lordship,
6/1/23 annexure I
and
and
8/11/2021 Annexure H, Lordship.
annex so and so have still not been responded to. First of, Land Council for the respondent does not dispute the fact that no objective consideration has been made of the.
I appear for the NHM manner. And we have filed an affidavit, we have responded to the every amendment made in a PIL manner.
What about the representation? What have you done?
My respondent for it will be government manner.
Government, all right.
Lordship.
It is not disputed that the concerned officers of the government, officer of the government, that is the Chief Secretary, Government of Assam, has not, and the Superintendent of Police, Vigilance, Anti-Corruption Assam have not. But this is the FIR as a consequence. What more do you want?
Lordship, last one is with regard to only Nagaon district. My simple prayer is to other two representation may be disposed of accordingly.
May I submit, my lord? If this was their prayer, my lord, they ought to have made this prayer, my lord, at the very beginning. After they got a reply, my lord, now they are saying that representation.
No.
Doesn't matter if there is a representation. They have not been responded to. In view of the facts noted above, we hereby direct that upon a copy of this order being presented, or rather copy of this order shall be presented to the concerned officers who shall, objectively consider and decide the representations of the petitioner referred to Supra by speaking order within a period of 2 months from the date of submission of the order. In case any adverse proceedings ensue, the petitioners shall be at liberty to take recourse of the suitable remedy for the redressal thereof. With the above observations and directions,
Only one statement may be recorded, my lord. We have filed an affidavit on behalf of the respondent number 3.
the affidavit has been filed on behalf of so and so.
My lord.
The petition is closed with the aforesaid observations and directions.
Obliged.
उसे देना उसका पहले देख तो फाइल मंगा लिया.
Item 13.
Yes. Whatever your appeal is not maintainable. In a criminal case, writ appeal does not lie. Yeah, all right. You.
That is Supreme Court judgment.
Will give the judgment to us. Give it.
Two judgments.
Yes.
Yes.
What do you want to say from this judgment? You are citing judgments regarding maintainability of your petition before single judge. That is not the issue. Single judge order revision, this is not a revision. This is a writ appeal. And writ appeal in criminal cases does not lie. Immaterial, you go to the Supreme Court. You go to the Supreme Court.
Either in LPA or
No, LPA doesn't lie. give him this judgment. He's a very educated man.
I've sent in the net also. And
We are giving you a judgment. You be satisfied with that. No, give this back. We'll deal with it. We'll deal with your judgments. Take a copy of this. Take out this. ये निकाल के इसको दे दो.
it is wrongful or decision was passed by the gender.
You need to go to a higher court. We are not in a position to entertain your LP. That is what the Supreme Court says. LPA doesn't lie. Oh, नीचे list दे दी. Against an order passed by single judge in writ jurisdiction. Okay? वो निकाल के दिखा दो उसको.
Has it taken or LPA?
Same position. It does not lie. Tariwal Tobacco talks of second revision. This is not a second revision.
Then, but what is the function of the division bench, sir? My lord.
To hear matters,
I know it very well.
yes,
That whenever a person is aggrieved from the single bench.
yes,
then
not in every jurisdiction,
I have forgotten to bring it from my.
not in every jurisdiction.
Point out from the.
Mr. Datta, not in every jurisdiction, the division bench can entertain an appeal.
Now, if it is not maintainable, my lord, that might be rule.
We are giving you the rule. Now we have also directed that rule will be framed. Otherwise, Supreme Court says no LPA in criminal matters. That's it. That is the answer. You have not brought a judgment of LPA. We are giving you the judgment.
And repeat, my lord.
That is the same thing. LPA and writ appeal are one and the same thing. Office note nahi dijiye. Only the judgment. Call the next case. We'll deal with this.
Password meter 12.
Maloj, I apologize for not being here, Maloj. Maloj, it's that recruitment matter for ICU technicians. I'll just give a background, Maloj. There were 128 posts created permanently by the government during that COVID period. They then, Maloj, advertised.
Yes.
108.
To ask Mr. Joshi to join.
Joshi.
He was there when the matter was taken.
Lordship, I apologize for that. Maloj, 108 posts were advertised. They got 90, they selected 99. But out of that 99, only 90 joined. So, my lord, around 67. 90.
190.
No, my lord, 40 joined. My lord.
Okay.
99 selected, 40 joined. Then they again advertised that 67 posts.
Okay.
But this time, my lord, only 22 were selected. And my lord, in that selection list itself, it is said that the balance could not be selected because there were no so suitable and eligible candidate. So we were hanging. 1 year was to.
You are from which category?
22, my lord.
22.
22.
Okay.
Then, my lord, the appointments were not forthcoming. So, my lord, we approached this honorable. They filed a preliminary affidavit in September 2001.
Yes, yes.
September 2001, they filed an affidavit wherein they say that now we are the COVID situation now all have eased. So we are proposing to issue a fresh advertisement, amalgamating all these posts.
Okay.
And in future cancelling the selection. But the word uses in future. In December of that year, my lord, they publish a advertisement. But this time it's for that balance 47 only, not the amalgamated one.
Okay.
That 47 in 2023, they appoint, my lord.
They have already appointed.
Already appointed.
Okay.
47, not full, around 28, 29 people. And two of the appellants have also been appointed.
They have been appointed.
They have been appointed.
Then?
No, the fresh selection, my lord.
Okay.
In the fresh selection, they participated. They
So what is the grievance now?
The grievance is that 22, that list that is there, that, my lord, minus that 2 who have been now, the rest of the list till now.
Only 2 have been selected.
Only 2 have been selected.
Okay.
No, but that was a fresh selection, my lord. And that earlier selection still holds the.
Still holds good. That is, your case is that has not been cancelled.
Cancelled, and that has not been amalgamated in advertisement.
Okay.
Mr. Joshi.
Yes, Ms. Joshi. Yes. What is your stand? How could you keep them in hanging without taking any action either to cancel their selection? Was it conditional? Was it provisional? Was it periodic? What is your case? You have to unmute yourself. Unmute yourself, Ms. Joshi. Yes.
Sir,
Yes.
these 22 candidates who were selected, sir,
Hmm.
at that time, COVID situation started easing out. Because the selection mode was through Zoom call only.
Hmm.
They were not called physically and their skill test was not done. So government at that point of time decided to cancel, not to cancel, but not to appoint those people, sir.
Where is the decision?
Yeah, that was the decision, sir.
Where is the decision, Ms. Joshi? We are asking you.
Sir, in fact, against that particular thing, there was a writ petition and there was a order from the High Court also, sir.
Which order?
Maybe he's referring to this order, the impugn
This
order. maybe.
order, sir, came this, just a second, sir.
Ms. Joshi, we have asked you a very simple question.
Sir,
They were selected against your advertisement. Whatever
Sir.
mode you adopted, they were more than, other than these petitioners. There were more people selected in the first call, right? Are they working or not?
sir, this out of 22, nobody was appointed, sir, and nobody is working today.
Ms. Joshi, we are asking you, first round of advertisement, how many posts were advertised? COVID time.
Sir, first time 128 posts were advertised, sir, for ICU technicians, sir.
How many joined?
Out of
How many
120,
select?
yes,
Yes.
sir, 99 candidates got selected, sir.
Hmm. And how
sir,
many joined?
40 candidates joined, sir.
So their position is same as the appellants herein. They were also selected
No, sir.
by
No,
walk-in interview? No
No,
skill
sir.
test?
No, sir.
How
So
many?
that was a second advertisement, not the same advertisement. And in the second advertisement, sir, the mode of interview was different.
Let's see, where is the advertisement?
Lord, what's
Let's,
the First advertisement.
first advertisement.
First advertisement, my lord, would find at page 52, my lord, no, 47, my lord.
Yes. 47, yes. What is it?
What is it?
Hmm.
My lord, the
Permanent
earlier
post.
advertisements were cancelled. and
Yes.
This was issued. A walk-in interview will be held on so and so.
Yes. Hmm.
From 11 AM onwards at Auditorium Guwahati so and so.
Yes.
For recruitment of 128 numbers of grade 3 technical newly created permanent posts in respect of 32 intensive care units in so and so. So
Okay,
this, my
so
lord,
from this, how many were appointed?
my lord, the
46.
select list is at page 52, 99.
99.
40 appointed.
40 appointed.
Then, my lord,
Yes, so
fresh,
they did not undergo any skill test.
no,
Nothing.
nothing.
Okay, thereafter,
Then,
fresh
my lord, fresh advertising,
at page,
page in 55, my lord would
55.
see,
yes.
starting words,
Hmm.
in continuation of the earlier advertisement by so and so dated
Yes.
2/9/2020.
Hmm.
68 posts because 40
Yes.
had already joined,
Yes.
180.
So 68 and you were selected, where is the select
But
list?
that, my lord, page 58, 22.
Yes,
Out of
58.
this, my lord, document verification was undergone by 21.
Okay.
My lord would see the paragraph just after the names, my lord.
Hmm.
Numbers. Selected candidates are directed to collect their appointment letters on date and time from the venue, which will be intimated soon.
Yes.
So and so. Next paragraph.
Hmm.
Out of the 68 vacant posts in different categories advertised, only 22 posts could be filled up and the rest 44 posts
Hmm.
could not be filled up due to non-availability of eligible and suitable candidates.
Yes.
These posts which would not be filled up shall be advertised afresh on a later date.
Later date, yes.
Then that advertisement comes. My lord, before that advertisement,
Hmm.
I'll just like to place the stand of the government before the learned single judge,
Yes.
page 163. my lord.
Hmm. Yes.
Just preceding that, they say COVID situation has eased, so we
Hmm.
don't have a rush now.
Hmm.
Then they say, my lord, The health department is looking after the infrastructure already created and is likely to create even more number of posts depending on the need requirement. As ICU management is critical to life of the patient, therefore department is contemplating to have a comprehensive recruitment of such posts with due attention to the skill of the applicants in the relevant subject.
Yes.
In view of the above, the government is therefore proposes to issue a fresh advertisement at a later date after cancelling the earlier select list, not cancelled till then.
Yes.
Further, the select list has lost its validity.
Yes.
Now, my lord, this is of 29/9/2021. Now 173, my lord, would find.
Yes.
This is an advertisement of 7 December 2021. My lord, on the left-hand side top,
47.
47, my lord,
Yes.
ICU technicians. These were, my lord, then the process was completed and they were appointed, my lord, on 25/5/2023, my lord.
Okay.
So this 22 which were there, my lord, if my lord reads the select list also, it was confirmed that they would be appointed. And you said that we will amalgamate in September, but in December when you issue an advertisement, you save us and you proceed only for the balance.
Yes.
Now, my lord, we cannot be kept hanging because there is nothing here which, my lord, is
Yes,
illegal.
yes, Ms. Joshi, where is the order of cancellation of their selection?
Sir,
Tell us.
if I can
Where's the
submit,
decision? All right. Tell us the decision even. Where's the decision of the government to cancel their selection?
Sir, I have to examine the record, but what I know that based on the High Court order, sir, which came
Order,
on
Mr. Joshi? There's no
9/11.
order of the High Court.
There was order, sir. In the
All
writ
right, all right, come back on 11th with the order 12th.
My lord, I think he's referring to this 9/11/22 order.
Yes, sir.
Where is it?
That's, my lord, the impugn order. page 2.
Impugn judgment. Oh,
Impugn judgment.
that has nothing to do with
Nothing to do with
their select list. You come back prepared, give proper instructions to your counsel. Ms. Joshi, Avinash Joshi has joined.
We will be permitted to file one affidavit being that order.
Do it,
If it is
do
the
it.
office record also, we'll keep it. on
Yes,
record,
do
my
it,
lord.
do it. Appear through VC. However, we are not satisfied with the projection made by Ms. Joshi regarding the fate of the appellants herein who were selected pursuant to the advertisement dated so and so on the post of so and so.
Advertisement given amount.
Thus, you have not filed an affidavit in writ petition.
Yes, we are.
That
filing-
preliminary
that
affidavit
is
was
placed by the
All right,
appellant.
we permit the learned counsel for the health department to file a detailed affidavit
Lordship.
in the intervening period, re-notify on
11.
17th October.
Of like,
A pertinent explanation shall be offered as to the fate of the select list dated so and so by which the appellants herein were selected because till this date, comma, no government order cancelling the selections so made has been placed on record.
My lord, the select list is 3/11/2020.
3/11/2020.
Much of.
17th October. Yes. Yes, call him now. Yes, Ms. Datta. Yes. We are not bothered. It lays down the principle.
Matter is bribery. Subject factor, the circumstances of the case is bribery.
Okay.
Bribery and other land.
Okay, very well. We are dismissing your appeal. You go, if you want, you can go to the Supreme Court. We are dismissing your appeal. Rejected. Next. Not maintainable. You take your remedy wherever it lies. Your appeal is not maintainable. Okay.
Top of the list matter, item 1.
वो ले लेना वापस जजमेंट जजमेंट और गिव हिम अ सेपरेट कॉपी सेपरेट प्रिंट आउट दे दीजिए उसको ये विल नोट योर जजमेंट्स ये नोट कर लीजिए उसको वापस दे दीजिए नोट करके then note these judgments and give it back. Yes, please.
May it please your lordship, on our last occasion, we got stuck lordship on a word lordship. Whether lordship selection, if your lordship remembers lordship, we in a high court lordship.
Our memory is no photographic as yours.
Sorry lordship.
Mr.
This is
Bhagwati.
relating to lordship. promotions, Lordship, of a typist superseding grade 3 employees, Lordship, in the secretariat. On the earlier, while Lordship, the grade 4 employees require 7 years to get the post of a junior administrative assistant, Lordship. Grade 3 people require 8 years by the amendment they made. That I had challenged.
That is understood.
Lordship.
Okay.
Lordship, in running page 138, Lordship. Running page 138, Lordship, Lordship got it, resigned there. Lordship, our High Court has that similar kind of appointments, Lordship. So Lordship, 4 years are required for computer assistant, which was earlier in the secretariat also.
Yes.
But subsequently they made it 8 years total.
So
we
the High Court still period is 4
4
years. Okay.
In secretariat, they made it 8 years.
8 years.
4 plus 4. But for the typist, Lordship, for the grade 4 employees, Lordship, it has remained as
7 years. Okay. Okay.
So because of that reason, Lordship, they are superseding us. That was my point raised, Lordship.
Okay.
And
What is their explanation? Let us see. So your argument is that this is discriminatory and rather
Lordship.
this is degrading, as a matter of fact, that a grade 4 employee is getting precedence over a grade 3 employee. So how do you say that typist is a grade 3 post? Where from we get it?
Lordship.
What is the channel of promotion of typists?
Lordship.
Where is it? Let us see.
Lordship, in their rule itself, Lordship, it is page 63, it starts from page 63.
63.
On the last occasion, I had clarified your Lordship, but
Bhagwati, now the composition of the bench is different. There is no last occasion now.
page 61, Lordship, that is the typist.
61.
Lordship.
Okay. Yes.
Selection appointment to the post of typist, selection grade will be made by selection on the basis of seniority come merit.
From amongst
typist
Yes.
ordinary grade.
Yes. So this is the first promotion as per them.
Lordship. Below it is Lordship ordinary grade. Serial number 10, Lordship. Ordinary grade appointment to the post of typist ordinary grade shall be made by direct recruitment.
So you are basically typist ordinary grade,
Lordship.
right?
Now we are called.
Now is a different position. Initial appointment was as typist ordinary grade.
Lordship.
Okay.
Initially, the condition was to get the post of lower division assistant.
LDA.
There was a requirement of only 4 years. 4 years as a typist, ordinary grade. Then within that 4 year, we are promoted to typist selection grade.
Selection grade, yes.
Thereafter, we became eligible for the post of lower division assistant Lordship for within that 4-year period Lordship, after completing that 4-year period.
So either it is selection grade or LDA. The period is 4 years old.
Lordship, that was the rule, Lordship.
Okay.
Lordship, by their amendment, Lordship, which we have challenged, Lordship, they have made it, Lordship, requirement is made.
Page
79, 77. 77, Lordship. Rule 8, okay.
Yes.
By selection among grade
senior grade typist.
Senior grade typist
yes.
of the secretariat who possesses a degree of university. This degree has come in later, Lordship. Initially, it was higher secondary, recognized by the government, and also possesses any such qualification as laid down in clause so and so, as amended, and have rendered at least 4 years of continuous service on the first day of the year on which the selection is made, provided that the above qualifications shall not be applicable to existing senior grade typists who have rendered their service as typists since 87 to 1992. Lordship, below Lordship, at serial number 3, by selection from grade 4, staff and record suppliers of the secretariat who possesses a degree of university recognized by the government and also possesses any such qualification as laid down under clause so and so, rule 18 as amended, and have rendered at least 7 years of continuous service in secretariat on the first day of the
So you are agreed by basically insertion of senior grade
Lordship.
in this.
Lordship, exactly, Lordship.
Okay. So what is your case based on? What is the ground?
Ground is Lordship, I have already referred to Lordship because of that Lordship, because subsequently what they did Lordship. They had, there were too many vacancies in that post Lordship senior grade assistant. So they, on a number of times, they had relaxed it Lordship. In 2012, only Lordship, they had relaxed it Lordship.
Relax, there's 8 years requirement, 4 years requirement.
It was requirement Lordship, 4 years was applied and the promotions were made. And then that relaxation was cancelled. That relaxation was cancelled. Again, Lordship, again vacancy arose. It was not, people were not available in that post Lordship. So they again relaxed it Lordship.
Okay.
Twice, thrice Lordship, and that has been going on. They relax, promote some people, and they cancel it. That relaxation gets cancelled, and that has been going on Lordship. Subsequently, Lordship, now Lordship, they have what they have done. They have made the 8 years to 6 years.
Now they've done it 6 years.
They have done it 6 years.
Where is that 6 years?
6 years, Lordship.
When was this introduced?
Lordship, I'm coming to it.
Is it on record?
22 Lordship. In our IA Lordship.
IA.
IA Lordship, I have filed an IA. Lordship, page, running page 88.
Of the writ appeal for IA.
IA Lordship. 3690 Lordship. Running page will be 88. Running page. No, there is no running page Lordship.
No, there is.
80.
What is the date of the notification?
13 June 2022.
Annexure M.
Lordship.
Okay, so they have made it 3 years each.
3 years each.
Oh.
So Lordship, still Lordship, we are suffering because they have already been promoted. That I have brought in my.
No, but now you will get benefit of this 3 years. Why not? But you can't march over in seniority because they are not a party to this writ proceeding.
Lordship, initially Lordship, we had placed before. And another thing, Lordship, while this thing was going on, Lordship, they made fresh advertisements and also appointed some persons, Lordship. That was also under silence before this Honorable Court, Lordship. And the Honorable Court had
appointed as what?
Appointed in the post of junior administrative assistant, Lordship.
JAA.
Straight away, Lordship.
That why can't they do?
Direct-
Why can't they do? What is the prohibition against direct selection? That is one of the modes of selection.
Lordship, that is a mode of selection.
So then what is the
Lordship.
problem?
That they can do. There is
Then-
no doubt about it. But
then-
what happened, Lordship? Because of the imposition of the 8-year period, Lordship, we were not being promoted. Otherwise, we
Now it is 6 years. Now what is the grievance?
but they had already been promoted,
But
Lordship.
those who have been promoted,
Lordship.
they are not party to this writ petition. So how can we pass an order to their detriment,
But
thereby promoting
while they were
you?
given appointment, Lordship, in the appointment letter only, Lordship, it was reflected that this will be outcome of the, this will be a result of the outcome of the Honorable High Court's order, Lordship. Those appointment, Lordship,
Whose appointments?
they are upon the direct recruitees, Lordship,
The direct selection.
direct selection.
Direct selection, they are not before us. And that is a mode of selection. What is the problem in that?
Because of that, Lordship, they got seniority before us when we were.
Obviously,
when we
obviously.
were already.
That's, you see, either the court would have stayed that selection, which is not the fact.
Lordship,
So then how can you?
Lordship, it was,
And then, Mr. Bhagwati, tell us, you are an exponent of service law. Without hearing a person, can you be given a higher gradation?
Lordship, that is there, but when we bring the case before this Honorable Court,
We
Lordship,
understand.
Lordship,
But what can be done now? Implead them, then we'll consider your case that no, you are to get this 6 years has to be read retrospectively. So you will be deemed to have been promoted on completion of 6 years. So that direction, can we change the gradation? Seniority now, by virtue of that
But,
act.
but Lordship, when we made it 8 years, Lordship, we were already suffering, Lordship. We approached them, Lordship.
Understand, but well, that is the problem with pendency of the cases. Cases not decided in time. We have cases wherein after 10 years custody, the accused is released, saying that it's a false implication. Can we bring back those 10 years? That's a system.
Lordship,
We have to survive in that system.
Lordship, since these are service matters, Lordship, and they are suffering, Lordship, why can't that be done, Lordship?
Why can't then you implead them? Those who have taken a march over you, implead them, then we'll consider.
In the running years, Lordship, there have been lots of such kind of Lordship promotions, Lordship. They can at least, Lordship, try to solve the matter, Lordship. 6 years also, we are aggrieved, Lordship, but in the High Court rule, Lordship.
It's 4 years.
It has remained 4 years, Lordship. Why was it necessary to make it?
Assuming you have now all crossed 8 years.
Lordship.
So now you've been promoted.
Lordship.
So your only heartburn is regarding seniority.
Lordship.
Without the persons who have been promoted over and above your clients being heard, whether we can give that direction. You just given was one judgment on that aspect. You will have to make them a party in representative capacity. That is a law, right?
Lordship.
If not each and every one of them, at least some of them in representative capacity.
Lordship. That is a difficult thing, Lordship, because of and it is not a case, Lordship, that we didn't come in time, Lordship.
We are not at all blaming you, but during the course of the time, you should have woken up and implemented those people. As well.
Another thing, Lordship, when vacancy was there, they admitted that vacancy was there. When we were available there, why go for, Lordship, other appointments, Lordship?
What is the proportion of the direct selections vis-a-vis the promotions? What is the breakup?
Lordship, proportion is there, Lordship. Proportion, according to proportion only, Lordship, they have admitted in the affidavit that this much posts were lying vacant, Lordship.
All said and done. What can be done now? Tell us.
Lordship,
What relief can be granted?
At least they have to work out, Lordship. Let them say that we cannot do the workout, Lordship.
Why should they say? They say that hear them, the other side who are affected. They simply say, we say that we will not pass an order without hearing the persons who are likely to be lowered in seniority if we grant you the relief sought for. Take a decision.
Lordship, I have to consult my clients, Lordship. If they wish, I will make appropriate arrangement, Lordship.
Place for time so as to take instructions from his clients as to whether, it would be feasible to implead those persons as a party to the proceeding who, during the pendency of this petition, have been selected/promoted as JAA to the detriment of the petitioners, thereby, bringing them lower in the order of seniority in the cadre list after 4 weeks.
Item number 2.
May I please, Your Lord?
Yes, please.
My lord, the matter relates to, my lord, selection and appointment of the, my lord, Assam Forest Protection Force constables.
2009.
My lord, litigations are going on, my lord. My lord.
Don't know whether at this stage any interference can be made. It's too late in the day.
My lord was pleased to, my lord, ask from my learned friend that what is the status regarding those persons, my lord, who has already been given relief by the learned single judge, my lord. Whether
relief means in the sense,
my lord, we clubbed together altogether 15 petitioners, my lord. Now the learned single judge has given relief to the 9, and my lord, the rest of the 6, my lord, persons, my lord, are given relief to the 5 petitioner, 5 petitioners. my lord.
all right.
My lord. Now we have been segregated that we have our prayer and, my lord, our relief was sought for before the learned single judge is little bit different. My lord. That is actually not the case, my lord. The prayer as well as the entire relief which we seek, my lord, was exactly similar, my lord. Lord, only thing is that the pilot may be pleased to, my lord, peruse the impugned order, my lord.
Yes, please.
My lord, is that starts at page 195 and the relevant part, my lord. Paragraph 8
8
from page
Yes.
197.
Read, please.
May I read below? Under the normal circumstances, generally when there is a tie of marks awarded for the two candidates, the principle of adding weightage for the extracurricular activities are required to be considered. And accordingly, a candidate possessing NCC certificate or those who have represented the state in sports, martial arts, etc., or having skills in trade crafts like the computer, motor driving, electrician, etc., are given due weightage. In the present case in hand, on the basis of record produced.
Yes, we asked you what happened to those candidates,
My lord.
those 5 candidates. Who are them?
My lord, as of now, my lord, exercise is on to, my lord, they will have to get age relaxation. That process is on, and they'll be accommodated in the next, my lord, recruitment process.
So still they have not been appointed.
No, my lord, because age relaxation has to be there.
Okay.
My lord.
Okay.
So, my lord, in this manner, my lord,
That exercise, you have not been given any discretion. There's a direction to give them age relaxation.
That is being given, my lord. We are just waiting for the next round of this constable opening.
Okay.
so, my lord, can we be, my lord, considered in the similar line, my lord?
Similar lines, you make out a case of
My
clarity.
lord, yes, my lord.
Yes.
Now, in absence of any clarity in the records produced with regard to the effect where the due weightage was given to the concerned petitioners, number 1 to 8, 9, and 14, this court is unable to arriving at a finding that the parameter as reflected in the advertisement dated was duly followed for giving due weightage to the petitioner number 1 to 8, 9, and 14 for possessing extracurricular qualification as mentioned therein. Under such circumstances, the court is of the considered view that the said petitioner numbers 1, 2, 8, 9, and 14 have been able to make out a case which entitle them to the following directions.
Yes.
My lord, these are the directions has been issued. My lordship has already gone through, my lord. And now, my lord, in
How this segregation has been done,
Lord,
that only,
my lord, that is the issue, my lord. That segregation only, the learned single judge has said that some extracurricular activities
of NCC
NCC and something.
and computer.
My lord.
So what was the basis for this segregation?
The NCC certificate, my lord, will see advertisement at page 39.
We are asking you, page 39,
139.
139.
But there was a ground taken of assailing this process that caste norms were not followed. But my lord, the learned single judge, my lord, has upheld that it was substantially complied and refused.
Where is the advertisement?
Advertisement at page 139, my lord.
139.
Weightage part is after the viva voce, similar. Weightage will be given to the following category of candidates.
Yes, weightage.
My lord, candidate possessing NCC certificate.
One was given, petitioner number 1, my lord, possessed the NCC certificate.
Okay, so that is the distinction which has been drawn.
My lord. Petitioner number 2, my lord, who was given relief, my lord, he had a certificate in computer application.
Okay, the others didn't have that called certification.
No, my lord. They
Then-
had, my lord, certain only one person had done a programming in Tele. One person, other ground of challenge was caste.
Tally is nothing.
My lord, there was a challenge in caste. And also, my lord, one person is, he claims to be a champion in Kabaddi, but whichever, my lord, whatever. which
No
is a
certificate.
Group,
My lord.
which is a group event, my lord.
My lord, the learned single judge, my lord.
Let's see your pleadings then. What have you said? Which of the petitioners possesses what?
My lord, the.
Starts at page
I read
50.
petition at-
So one NCC, one competition of game sports.
My lord, page.
All right.
Yes, my lord, from page 49 is my read petition.
Yes, let us see. You prepare a chart then. From your writ petition, prepare a chart.
My lord, I will submit.
Counsel for the appellant
My lord.
shall prepare a chart of the extra curricular activities / certificates held by each of the writ petitioners, including the 5 who have been granted relief by the learned single judge. This chart shall be prepared strictly on the basis of the pleadings
Yes, my lord.
in the writ petition. List after 2 weeks.
My lord, oblige, my lord.
Yes.
And thereafter the.
दिखाना भाई क्या बता रहा है? What is he saying?
My lord, maybe he's referring to item 13. where-
We know. What is the judgment? Take out from his phone.
Oblige, my lord.
Maybe. What is the name of the judgment? All right, let's see the judgment. In person, we have to be more careful. रुको, wait. Just hold on, let us see what you have given. Your writ appeal can't be entertained. We are very sure of it.
Another so many cases will be there, I think.
Don't worry, we'll give you the opportunity of going to the higher court and getting a proper order. इतना बड़ा judgment.
Actually, my lord, I approved before the Supreme Court Legal Service Committee. But still now, it is more than 2.5 months they are pending.
Can't help it.
And here Legal Service Committee, I cannot approve because of my pension is more than 3 lakhs.
Yes.
For this reason, I could not approve.
That's right.
Can you help me, my lord? I am very much aggrieved.
All right, you have a remedy elsewhere.
I am very much victimized, my lord. I am 70 years old.
Yes, that's
I
right.
am purchaser of 3 nothing else, my lord.
Yes, this judgment, thereafter, the Supreme Court has given a larger bench judgment. This is by 2 judges. What we have shown you is by 3 judges. Okay? So this judgment doesn't help you. This is not a good law because of what we have said. Okay? But we'll take note of this judgment also. Thank you. Dismissed.